MJ, can you call the roll?
Mr. Chair, you have a quorum.
Thank you, MJ. Ladies and gentlemen, welcome to the second post-crossover meeting of the Courts of Justice Committee. We're going to do identical cognates first. We're going to break that down between uncontested, contested, and bills that have to go to finance, and then we're going to do cognates that have some similarities, same kind of structure, and then we're going to do cognates that had Senate versions that were continued or did not report, and then we're going to do new bills at the end. So that's the structure we intend to follow today. I know a lot of people, we have 20 people on the sign-up list, but we need to get through that structure first before we defer to the sign-up list. So, having said that, first up we have House Bill 202 by Delegate Williams about optometrists, which is identical to my bill. We have House Bill 264 by Delegate Hope, which is identical to Senate Bill 157 by Boysko. We have House Bill 332 by Delegate Jones, which is identical to Senate Bill 63 of McDougall, and we have House Bill 336 by Jones, which is identical to Obenshain 471, all 8 of which were uncontested. Senator Deeds moves, Senator Boysko seconds that we report those bills in a block. Clerk will open the roll.
Ayes 10, no 0.
Thank you, MJ. Next up, we have House Bill 1462 by Delegate Laufer. That bill is identical to Senate Bill 447 by Senator Marsden about firearms and unattended vehicles. The bills are identical, and they were contested, I believe, passed on a party line vote.
Move to report.
Senator Deeds moves, Boysko seconds that the bill be reported. Clerk will open the roll. Okay, thanks.
Ayes 7, noes 3.
Thank you. Thank you. All right. Then next up, we have 2 more. We're going to have to do them separately because they were contested. First up, we have House Bill 861 by Delegate Hernandez, which has to do with weapons in a hospital or a mental health facility by bringing guns into a facility. It is identical to Senate Bill 515 by Senator Williams-Graves, but it does need to be re-referred to Finance. Senator Deeds.
Report, re-refer.
Senator Deeds moves, Boysko seconds. We report, re-refer the bill to Finance. Clerk will open the roll.
Ayes 7, noes 3.
Bill reports and re-refers to Finance. Next, we have House Bill 896 by Delegate Hernandez, which has to do with Social Security benefits, basically saying that the Social Security SSI benefits can't be garnished for payment of fines. It's identical to Senate Bill 625 by Bagby. I can't remember whether this was contested or not. Was this contested? Okay, it was unanimous. It needs to be reported and referred to Finance. Senator Deeds moves, and Boysko seconds to report and refer to Finance. The clerk will open the roll.
Ayes 7, noes 4.
Okay, now we're on to cognates that have similarities but are not identical. First up, we have House Bill 140 by Delegate Reed. This has to do with making sure that adopted children are not foreclosed from having included in the class of beneficiaries in a wrongful death case. It's identical to Senate Bill 209 by Delegate Perry. Yes, sir. Senator Peake.
Fix 896.
Yes, sir.
Switch me to yes and Obenshain to yes. All of us
Okay.
to yes.
So Senate Bill
It
896
was
will be
going
a...
too fast. I couldn't get that far into my...
It's no problem.
Hey, thank you. It's all to yes.
Yeah, so 896 will be reported and re-referred unanimously. So back to House Bill 140 by Delegate Reed, which is identical to Perry. I believe the patrons have talked, and we're not going to conform the bill to the Senate cognate, so we're going to report this bill as
Move to
is.
report.
It's been moved and seconded to report the bill. Clerk will open the roll.
Ayes 11, no 0.
Thanks, MJ. Next, we have House Bill 676 by Delegate Lefwich, who's not present, but authorized us to proceed in his absence. That bill is similar to Senate Bill 566. We just going to conform it, or are there amendments?
Mr. Chair, in courts for Senator Deed's Bill 566, we just extended the objection period from 45 to 60 days. So there'll just be two line amendments to conform on lines 25 and 30.
But Sabrina, are we just conforming it straight up, or are there specific amendments?
It's just conforming amendments.
Okay,
Yeah.
Senator Deeds moves to conform. Boyce goes seconds. All those in favor say aye. Aye. Anybody opposed? No. Okay, Senator Deeds moves. Boyce goes seconds. The bill be reported. Clerk will open the roll.
Ayes 12, no zero.
Okay, House Bill 772 by Delegate Delaney has to do with parental admission of minors for inpatient treatment. It's a recommendation of the Virginia Commission on Youth. It's similar to Senate Bill 460 by Marsden. Is that amendments, or are we conforming?
I think we want to conform it to least.
I think we want to.
Okay, it says Senator Deeds moves and Boyce goes seconds. We conform the bill to Senate Bill 460. All those in favor say aye. Aye. Anybody opposed? No. Okay. Senator Deeds moves. Boyce goes seconds. We report the bill. Clerk will open the roll.
Ayes 12, no zero.
Thanks, MJ. House Bill 895 by Delegate Bennett Parker has to do with venue protective orders. It's similar to Senate Bill 211 by Perry. I believe the patrons have spoken. We're going to leave the bill as is. Senator Deeds moves and Boyce goes seconds. The bill be reported. Clerk will open the roll. You're not conforming. You want an explanation?
Ayes 12, no zero.
You want an explanation or no? The bill reports. Okay, next up, we move into bills that are similar but were contested and not uncontested. So we have House Bill 1252 by Delegate McClure. This has to do with limitations on revocations of suspended sentence. It's similar to Senate Bill 505 by Senator Subramanian. I think we're conforming that. Completely conforming, right, Senator Subramanian? Okay, Senator Deeds moves, Boyce goes seconds. We conform the bill. All those in favor say aye. Aye. Anybody opposed? No. Okay. Remember, this was a contested vote. Senator Deeds moves, Boyce goes seconds, that the bill be reported. Clerk will open the roll.
Ayes 8, noes 4.
Okay, next up, we have House Bill 1420 by Delegate Watts. This has to do with the minimum age that a juvenile can be charged with delinquency proceeding in juvenile court. It's similar to Senator Locke's bill. It's my understanding the patrons have spoken, and we're going to leave this bill as is, and it was contested. Senator Deeds moves and Boyce moves. The bill will be reported. Clerk will open the roll. Well, hold on a second.
You said we're going to leave it as is. What does that mean?
Taylor, can you
What are the
describe to
differences?
Senator McDougal what the differences are in the bill?
Yes, Mr. Chair, the two bills are substantively the same. There are just minor technical differences. In the House bill, it's correct. Like, for example, minor commas versus semicolons, 18 versus spelling out 18th, and minor technical amendments, nothing substantively different.
You good? Good enough to go?
Bad policy, but I'm good to vote.
Got it. All right. McDougal is not good to go, but good to vote. All right, clerk will open the roll. I think somebody moved, didn't they? Okay.
Ayes 8, noes 4.
All right. Next up, we have bills that need to go to finance. First up, we have House Bill 2 by Delegate Hummer, which has to do with assault firearms. It's my understanding the patrons have spoken, and we are going to leave the House bill as is, but make some technical amendments about VMI and Virginia Tech, I think. Are those amendments in the... Actually, Senator Deeds, first, you want to explain the differences? Or this was a kind of a big bill.
This is a big bill. The difference is than the House version. The House version allows you to buy a new weapon in West Virginia and transport it home. So you can possess and transport. And the bill that we passed out of here said you can't possess, transport, or you can't have a new firearm.
Okay. And we're
So that change we're going to agree to because we're going to try to keep the bill out of conference. The other change basically says that if you're in a military school, you can use one in accordance with school policy. And that really only affects kids that are students at VMI and Virginia Tech, the Corps Cadets.
Taylor, have you done this as amendments or as a sub?
Mr. Chair, this is a substitute, and it has been passed out to everyone.
Okay.
I can, point out the
Got it.
changes
Okay, so
if you
Deeds
want.
moves, Boyce seconds, the substitute. All those in favor say aye. Aye. Anybody opposed? No. Okay, so the bill's before us.
Move to report and re-refer to finance.
Okay, Deeds moves, Boyce seconds, the bill will be reported and re-referred to finance. Clerk will open the roll.
Ayes 8, noes 4.
All right, next up, we have House Bill 22 by Delegate Jones, who has quite a few on our docket today. And this has to do with auto sears, and which was similar to Senate Bill 210 by Senator Perry. We have a new substitute, I believe. So Senator Deeds moves, Boyce seconds, the substitute. All those in favor say aye. Aye. Anybody opposed? No. Taylor, can you describe to us how the substitute is different than the bill we voted on before?
Yes, Mr. Chair. The substitute, instead of creating a new standalone statute for auto sears, it adds auto sears to the current statute that prohibits trigger activators. So it still defines auto sears, the same definition as the one that the Senate bill reported out, and it still also adds auto sears and trigger activators to the forfeiture of weapons statute. And the substitute has been passed out to everyone in the stapled packets.
Does anybody have any questions for Taylor or Delegate Jones here? Did he leave?
Mr.
Oh, there he
Chair.
is. Yeah, Senator Perry.
I'll just say that that was done, Delegate Jones and I spoke about this. It was done at the request of the Commonwealth Attorney's Office to try to make sure that they were in the right statute when they charged, and my forfeiture provisions were added to his bill, and it keeps it out of conference, which I know is important to the chairman.
Yes, we don't want a lot of conference committees this year. Any further questions? Senator, looks like McDougal's light's green.
Mr. Chairman, so this was a separate statute when it came through with Senator Perry's, and does this code section do anything different than what, putting it here, does it do anything different than when it was a standalone statute?
Mr. Chairman.
Senator Perry.
Senator McDougal, the answer is no. It doesn't. It just moves it over so that it's easier for the Commonwealth, right? They don't have to determine, is this a bump stock? Is this an auto sear? They can just charge whenever they see that machine gun-like action happening.
After this one. Okay, any further questions?
Mr. Chairman,
Yep, Senator McDougal.
on line 17, why did we change or add that word there in the substitute?
Mr. Chair, Senator McDougal, are you talking about where we add trigger activator?
Senator McDougal, I think you deleted trigger on line 13, so I think you had to add it on 17.
Okay.
Yeah, okay. All right. So we good to go, or good to at least vote? Okay, Senator Deeds moves, Boyce seconds, the bill will be reported, referred to finance. Clerk will open the roll.
Ayes 13, no 0.
Okay, bill reports refers to finance. I need to get over to higher ed subs, so just really quick, I'm going to call 838 out of order really fast because that is identical to mine, just so we're clear. And then I'm going to turn it over to Senator Deeds. House Bill 838 by Delegate Hope is an expungement bill. It is similar, but much, much, much smaller than my bill, Senate Bill 504. I believe that I've talked with Delegate Hope. Is he here? There he is. I think he's in accord with my suggestions, and we have a substitute. So Senator Deeds moves, Boyce seconds the substitute, which kind of conforms his to one little part of mine, and then the rest of mine will live alone by itself. All those in favor of that substitute, say aye. 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 Anybody opposed?
Move to report.
No. Say, yeah.
Mr. Chairman, I know you're trying to move quickly, but
Yeah, I get it.
don't.
Senator McDougal, go
Can
ahead.
you articulate a little clearer what the differences are?
Yeah, so I believe that I believe that Delegate Hope's bill was an attempt to simply reverse two Supreme Court cases, which my bill did. And mine also attempted to confirm a Court of Appeals opinion, lock it into statute about what manifest injustice means. So that it's clear that manifest injustice refers to any hindrance to obtain employment, education, or credit, which isn't in the code right now, but the Court of Appeals held that's partly what manifest injustice means. That's on lines 68 and 69 of the bill. The bill also takes what at least I thought the law was on expungement back to what it was before the two Supreme Court opinions came down this year. If you remember, the bill that I presented and passed the Senate had about 7 or 8 more policy changes in it relating to court-appointed counsel for expungements, and had to do with private background check companies getting lists of expunged charges and being subject to criminal liability for continued publishing charges, and a few other things. But Delegate Hope's bill is a much smaller bite. He didn't want to take off the big bite.
Mr. Chairman, if I remember correctly, your bill had one version here, a different version in finance before it went out. So which is this closer to?
Okay, so Senator, what happened to my bill in finance is we had to put a delayed effective date on it because of the Virginia State Police's deployment of their new criminal record check system, and we didn't want to interfere with that, which is slated to go live on July 1 of 2025. And actually, mine's going to need some more surgery over in the House to clean that up. But that was the only substantive change that happened to my bill in finance. The policy didn't change. It was just a delayed effective date.
Mr. Chairman?
Yeah.
Does this bill not have that delayed effective date?
It does not, because it doesn't need to, because it doesn't affect the guts of the automatic sealing system and all that, like mine did. Straight? Okay, higher ed is blowing up my phone to me to get out of here. The bill's before us. I think it's been sort of conformed.
Report and we refer to finance.
It's been moved. Bill will be reported, referred to finance. Clerk will open the roll.
Okay, and you want me to continue these bills that
Yeah, you take over, yeah.
Ayes 8, noes 5.
Okay, the bill reports refers to finance. I'm going to turn it over to Senator Deeds while I go present.
Okay, House Bill 155 from Delegate Green is similar to Senate Bill 646 from Senator French, reported out of this committee unanimously, reported for Finance unanimously, and passed the Senate. 646 was conformed to the House version on Friday in House courts. It covers claims of any sexual abuse of a minor. The Senate bill, the House bill covers claims of any sexual abuse. The Senate bill covered claims of sexual abuse of a minor where the conduct constitutes a felony. So what's your pleasure? Do you want to conform, or do you want to?
I have a question. Could I get, Mr. Chair, could I get some clarification on the statute of limitations?
Taylor,
Is that being changed at all? Is it being shortened or expanded?
Mr. Chair, this bill is dealing with when someone can file for a claim under the Criminal Injuries Fund. So the bill is extending the statute of limitations for when someone can file that claim. Under current law, in cases involving claims of sexual abuse of a minor, those claims have to be filed within 10 years after the minor's 18th birthday. So this bill would say that there's passage of time is not a barrier, so there's no statute of limitations.
So the difference between the House bill and the Senate bill is the Senate bill is more narrow. It says that the sexual contact had to be felonious, and this applies to all contact.
Mr. Chair, that's correct.
Okay.
Mr. Chair, I move to report.
With that, report and refer to finance. Okay. Motion is to report and refer to finance. Please open the roll.
Ayes 13, no 0.
Okay, the bill reports and is referred to finance. The next bill on the list is Senate Bill 1, or House Bill 173 from Delegate Simon. It's similar to Senate Bill 100 from Senator Eben. They're reported from this committee with a substitute 9-6, reported from Finance 10-5, and passed the Senate on a party line vote. It's reported as is on Friday from House Public Safety. Substitute to conform to the Senate bill. We have a substitute before us. It conforms to the Senate bill. It just makes technical changes. Senator Boysko moves the substitute. Delegate Bagby seconds. Senator Bagby, I apologize.
I like delegate.
All in favor of conforming, say aye.
Aye.
Okay, is there a motion on the bill?
Move to report.
Report and refer to finance. A motion to report and refer to finance. Is there a second? There's a second. Please open, unless there's an alternative motion, please open the roll.
Ayes 8, noes 5.
Okay, the next is House Bill 183 from Delegate Simon. It's similar to Senate Bill 368 from Senator Boysko, which was reported from Senate courts with amendments 9-6 and passed the Senate 21-10. As far as I know, Senate Bill 368 was reported from House Public Safety on February 16th. Senator Boysko, we have a substitute, I think, it makes technical changes to conform the bills.
Move to conform.
Move to conform. Okay, all in favor of that, say aye. Aye. Any opposed? Okay, is that my understanding that the bill, the changes also adds a firearm is loaded, stored, locked and stored in a biometric storage device. A prohibited person can't be an authorized user for the lock of such device. Does everybody? This is a safe storage bill. Do you remember the bill? Okay, is there a motion on it?
Move to report.
Motion to report and re-refer. This was a bill that came out of here, I think, on a party line vote. A report and re-refer to finance. It's been seconded. Unless there's an alternative motion, open the roll, please. Yeah, it's referred to report and re-refer to finance.
Ayes 8, noes 5.
Ayes 8, noes 5. The next bill is House Bill 612 from Delegate Price. The bill is similar to Senate Bill 654 from Senator Williams Graves. It reported from this committee on a party line vote. Reported from Finance with amendments and passed the Senate on a party line vote. It's my understanding that Senate Bill 654 was conformed to the House version on Friday in House courts. The House bill includes a delayed effective date to January 1, 2025. The Senate bill also passed with an amendment made in Senate Finance. It contains a requirement in current law for correctional facilities to withhold inmates' earnings from certain work programs to pay toward their fines and costs. Do you remember this bill? Could we have a substitute on this bill, Taylor?
Mr. Chair, I think it was the preference to report this House bill as is, but
Second.
Okay, a motion to report and a second. Unless there's an alternative motion, please open the roll. We re-refer to finance. Motion to report and re-refer to finance and a second. Okay, please open the roll.
Ayes 8, noes 5.
Okay. Now we have House Bill 1174 from Senator Sickles. It relates to assault firearms. It's similar to Senate Bill 327 from Senator Salim that reported from this committee on a party line vote, reported from Finance on a party line vote, and passed the Senate floor on a party line vote. It's my understanding 327 was conformed to the House version on Friday in House Public Safety. We have a substitute to conform HB 1174 to the Senate bill. It requires the person to be 21 years of age or older to purchase a handgun or assault firearm. Do I have a motion to
Move to conform.
Okay. Motion to conform and a second. All in favor say aye. Aye. Okay. Do you understand the bill? It has to go to finance if it's reported.
Move to report and refer to finance.
Second. Unless there's an alternative motion, please open the roll.
Ayes 8, noes 5.
Now we are at a part of the docket where we're dealing with House bills that are that had Senate cognates that were continued to 2025 or failed to report. And I don't know if it makes more sense for us to go by the list or
Mr. Chairman,
yes.
when we go over to the House, regardless of when we show up, they tend to go by the list.
They go
So
by
I
the-
think
okay.
we should go by the list.
HB 697 from Delegate Maldonado relates to synthetic media. The bill is similar to Senator Evans' 571, which we carried over in this committee. So please explain to us why this bill should be treated differently.
Thank you, Mr. Chair, members of the committee. Good morning. This bill is meant to address what we're seeing as a proliferation of synthetic media or deep fakes across a number of areas. What we have done and seen across a number of states is really looking at vertical, kind of siloed pieces of legislation addressing deep fakes and the use of revenge porn or political campaigns. What we're trying to do here is to treat it more like a horizontal. When you look at what kinds of crimes people are convicted of or found guilty of when using synthetic media, it tends to be in the categories of fraud, slander, defamation, and libel. So we looked at how do we provide additional teeth in the code in those sections to be able to address this proliferation. Otherwise, we're going to find ourselves creating siloed pieces of legislation going forward. On a parallel track, what we're doing is also instructing the Attorney General's office to continue working on this issue and form a work group to look at how to do this going forward in more fashion. But because we are in a 2024 grand election cycle, we want to make sure we put some proper guardrails in place. It does have whatever penalties are present in this part of the code and provides 2 additional pieces. Class 1 misdemeanor for fraud and Class 3 for slander and libel. And so the Attorney General's office testified in support of this bill in the House, and we think that this is a really novel way to address what we think is a proliferation of use of this kind of technology as we move forward.
Okay, thank you, Delegate. Taylor, are there differences between this and the Evan bill?
Mr. Chair, this bill is the same as Senator Eben offered and a substitute was adopted before it was carried over, and this bill is the same as that substitute that the committee was considering.
Okay, do members have questions for Senator or Delegate Maldonado? Are there others in the audience who would like to speak on this bill?
If there's anyone online that would like to speak in favor, please raise your hand.
Nobody? Okay, the bill's before the committee.
Mr. Chair, saying that the similar bill or the cognate was continued on, I move that we continue it to 2025.
Okay, is there a second for that motion? Second. Are there alternative motions? If not, please open the roll.
Ayes 11, noes 2.
Thank you, Delegate.
Thank you, Mr. Chair. Thank you, members.
Okay, Delegate Simon of 1114 is next. It's identical to Senator Aird's 643. It reported from this committee on a party line vote, but it failed to report in the Senate, or failed to report, I guess, from the floor of the Senate. It indicates that there was a tie vote there. I don't remember.
So, Mr. Chair, I actually have a substitute that I think may address the concern of the one senator who voted against it. And what this does is it really substantially narrows the bill down. As you all may remember, this was a bill that totally decriminalized failure to appear, defelonized it, and limited it to a civil contempt remedy instead. What this bill does is it takes out everything that bill did except for the part that says if you're incarcerated somewhere else. So now it will only not be a crime for failure to appear if you are in the custody of the state somewhere else. And so again, it's greatly narrowed down to get to one specific circumstance. I understand that the Commonwealth attorneys have a process that they're supposed to use to check to see if somebody's incarcerated somewhere else. So most of the time this wouldn't be a problem, but we don't put it on the person incarcerated if somebody messed up and didn't get them to court on time.
Okay. We have substitutes before the committee. There's a motion. Senator McDougal has a question first.
I'll let you do that.
Okay, adopt the substitute. All in favor, say aye. Okay, Senator McDougal.
Thank you, Mr. Chairman. Delegate Simon, looks like what you've done is what most of us thought the law is today, that if you're being held against your will in a correctional facility or state or local federal facility or by a court or other judicial officer, then you can appear. So I don't know how it can be willful failure to appear if you're legally prohibited. So we thought this is the law. But my question to you is, are you making us the guarantee that if this leaves this body looking like this, we won't see it again?
So, Senator McDougal, Mr. Chairman, I should go the other way. Mr. Chairman, Senator McDougal, yes, this is not a game that we're trying to keep this alive so that we can slap a substitute or reject the amendments and sneak it past anybody in conference. I would say I did speak to a judge the other day. Sometimes some judges look at this incarceration as sort of like a voluntary intoxication kind of a thing. Well, you did something willful to get yourself incarcerated, so it's still your fault, which is why I think this legislation is necessary. But I think I agree with you. This is what it's meant to be, and this is not a ploy to do this anything else. I can, if somebody tries to expand it again, I'd ask that my bill be stricken.
Mr. Chairman.
Are you satisfied, Senator McDougal?
Mr. Chairman, I'd love to know who those judges are because we probably should talk to them about what willful means. But I'd move to report the amended bill.
Motion and a second to report. Are there other motions? Oh, please open the roll. Do we have to refer this to finance?
No.
Okay, no.
Ayes 13, no 0.
Okay, the next bill is Delegate Shin's 1263, and if we refer this, if we report this, it does have to go to finance. This bill is identical to Senate Bill 481 from Senator Aird. It was reported with the substitute 11-4 from this committee, and I don't know what the vote. I think we have some of the vote. It was a bipartisan, more or less.
Mr. Chair, move to report.
There's a substitute to conform to the Senate bill.
Move the substitute.
Move the substitute. Okay, all in favor. And you have a copy of the substitute in your. We have a copy of the substitute, Taylor.
Yes, Mr. Chair. The
Okay.
substitute conforms it to the version of Senator Aird's SB 41 that this committee reported out to finance.
Okay, a motion to adopt the substitute. All in favor, say aye. Aye. Okay, what's your pleasure on the bill, Delegate Shin? Do you want to?
No, Mr. Chair, I was just going to come up to ask it be sent to finance.
Yeah, it'll have to go to
and
finance.
give it a fighting shot once more. Thank you.
Okay.
Move to report and re-refer.
Okay, motion to report and re-refer. Is that seconded? Okay, motion to report and re-refer. It's been seconded. Unless there are alternative motions, please open the roll. Thank you, Delegate.
Thank you.
Ayes 8, noes 5.
Okay, House Bill 63 from Delegate Simon is the next bill, and I don't think we've seen this before. So turn your attention to the delegate.
Thank you, Mr. Chairman, members of the committee. This is jury sentencing bill. So what this bill does, essentially it says, we allowed folks the option a few years ago to seek a jury trial, but then also opt to have their sentencing done by a judge. We made that policy change. The defendant in a case like that is supposed to give 30 days notice of what their intention is to do, how they'd like to be sentenced. What this bill does is it says that, it makes it clear that that election is revocable at the defendant's option. So the defendant can go, so imagine a scenario where you've had a bunch of charges stacked against you. You got 6 or 7 charges out of one incident that have been charged, and you say to the court, you know what? If I get convicted of all these things all on top of each other, I'd rather be sentenced by the judge because he understands the stacking, the strategy, and so forth, and that's how I'd like my sentencing to be done. After the trial's done, it turns out you're only convicted of one of those many charges. You're found not guilty of the rest, and you can say, you know what? given that they didn't find me guilty of a bunch of stuff, I might be better off actually being sentenced by the jury in this instance. And so I want to change my election and be sentenced by the jury. This bill says that's allowed.
I think we understand the bill. Okay. Are there questions of the delegate? It's a good bill. Okay, motion to report has been seconded unless there are alternative motions. Oh, I'm sorry. I apologize. Are there people that need to testify about this bill?
If there's anyone online that would like to speak to this bill, please raise your hand.
Okay, we've had a motion. Do you want to testify for or against? Come on up, Jim.
Jim Hensley, Albemarle County Commonwealth's attorney. Thank you, Mr. Chair. I'm representing Virginia Association of Commonwealth's Attorneys here today, and the Virginia Association of Commonwealth's Attorneys opposes this bill. There's really two parts to this bill. The first part I would address is the ability to revoke the election for jury sentencing up until the last minute before the jury retires to deliberate sentence. We have a great concern for the victim's testimony, victim impact testimony. If a victim is going to testify, they need to be prepared to testify and they need to be in court. And so this is initiating a process for victims of being prepared to give their victim impact testimony that at the end of the day, this bill says to these victims, you're here to testify, but you're not going to be able to testify. Now, this is a very serious disruption to the lives of the victims to be experiencing the trauma again and being prepared to testify about it. And they, it's unnecessary if it can be unnecessary by virtue of this bill. And what I would like to specifically address is that we think of victims, the direct victim of a crime, and that is a person who's going to be there at the trial anyhow. But the concept of who a victim is and who a victim may be testifying, giving impact testimony, it goes far beyond the person who's directly affected. And the statute says that victims can include the spouse or child of the victim who's directly affected, as well as a parent or guardian of a minor, as well as spouses, parents, siblings, and legal guardians of any victim who is mentally or physically incapacitated. So you have a lot of people whose only testimony at jury sentencing will be the victim impact testimony, and then to be told after they are ready to do that that they can't testify because the election has been revoked, the election for jury sentencing has been revoked, is really a very serious problem from our perspective and how victims are treated. The statute says victims must be treated with dignity, respect, and sensitivity, and we suggest this is not that. The second part of the statute is the proposed bill is to allow the range of punishment to be discussed in voir dire, even in cases where the jury does not ascertain punishment. That goes against the principle the Court of Appeals has established, as well as the statute itself, 19.2.262.01, that questions of jurors must be relevant. There's no relevance for a jury to know what the range of punishment is when the jury is not sentencing, and that's what this bill would allow. So we would suggest that the purpose of allowing the range of punishment to be discussed in voir dire with a jury who is not going to sentence is simply to invite the jury to have their deliberations on guilt or innocence affected by the irrelevant information of what the sentence is, and it's, in some respects, may even be an invitation to nullification. So we oppose it on those grounds. Lastly, Judge, the 30-day notice for the election of jury sentencing is a reasonable time period, and there's been some suggestion that maybe the case full discovery hasn't been given yet, and people are not in position to evaluate whether they want to have jury sentencing or not. And they should have that right to extend that election to a later time. The discovery order allows the court to set up a time, and so discovery can be completed within the 30 days when the election is made. Thank you.
Thank you very much. Anybody else?
Mr. Chairman, I have a question for the
Senator Carol Foy has a question.
not patron, for the BACA representative. Mr. Chairman, my question is, does a jury get to hear victim impact statements or testimony?
Yes.
Does a judge get to hear?
Senator Carol Foy.
Mr. Chairman, thank you. Follow-up question. Does the judge get to hear victim impact statements and testimony?
Mr. Chair, yes.
Okay. So I was kind of confused from
Senator
some of the,
Carol Foy.
Mr. Chairman, I was kind of confused with some of the testimony that he was given. Also, I would like to thank the patron for bringing forward this bill. I do take objection, and I respectfully object, if it's any Commonwealth attorney's position that not making full disclosure to the trier of fact, which would be the jury, of sentencing range is offensive. It flies in the face of the criminal justice system, where it should be about information, evidence. And so to hear that that there's some who would like to keep that information from the jury when these are the people who are making decisions about these people's freedom. They should be fully informed about the sentencing range and what the possible consequences of their verdicts are. And so it's very shocking to hear people say the quiet part out loud, but I think we should fully inform our juries and make sure they're making fully informed decisions.
I think there was already a motion to report, and it's been seconded. Unless there are alternative motions, please open the roll.
Ayes 8, noes 5.
Okay, Delegate Simon, I think you have two other bills. Do you want to go ahead and do them?
I do. If it's okay with the committee, I'll do that. Let me do I think the easier of the two. Next is House Bill 315.
House Bill 315, turn your attention to Delegate Simon. This
liens.
has to go to finance if it reports.
Okay. So what this bill does right now, DMAS is woefully behind. So if in a personal injury suit, if the injured person receives any kind of medical care or suffers damages that are paid for by Medicaid, DMAS gets a lien on whatever they've put out on the judgment of the personal injury judgment. Defense attorneys have to, they'll get their verdict, they'll put the money inside, they'll put it in their trust account, and then they'll wait for DMAS to tell them exactly how much is owed so that they can pay off the lien and close out the case. And that process is taking, in many cases, years. What this bill would allow attorneys to do is say, look, I'll do the calculations for you. If you guys don't have the staff, we'll do a calculation. We'll tell you what the fees are. We'll do everything we need to do. Give you essentially an invoice to approve or disapprove. Gives them 60 days to say, yeah, that number's right or it's not right. If they don't say anything, then that's the number we're going to use. We'll release the lien. So that's the bill, Mr. Chairman, in a nutshell. And it's really to get the Commonwealth to take our money, right? Can we please get you guys
Senator
paid?
Shane, what do you
quickly?
think? Senator McDougal's got a question first.
Mr. Chair, this is an outstanding bill, an outstanding idea. I'm looking right now at the FIST for this, which reveals that the outstanding folks at DMAS are clearing about 4.8 cases per week. I could lend them my paralegal, and they could clear 4.8 cases in a morning. And this is an elegant solution to a long-standing problem. I hope we would report this bill.
Okay, a motion and a second. Senator McDougal had something that,
Mr. Chairman, Senator Obenshane stole my thunder.
okay. It has to go to finance. The motion is to report and refer to finance. Unless there are alternative, are there people in the audience that have to speak to this bill?
If there's anyone online that
Anybody
would
want
like
to
to
get in
speak,
front of the
raise your
train?
hand.
Okay.
Mr. Chair, if I can just follow up with one more thing.
Senator Obenshane.
This isn't going to cost anything. This is going to be a revenue generator, and it's going to have lawyers doing DMAS's work for them, and is going to cut down on their workload. So I hope it does real well at finance.
Okay, please open the roll. Okay,
Ayes 13, no 0.
your other bill, Senate Bill 180, House Bill 184, correct?
Thank you. So House Bill 184, Mr. Chairman, you know, at the risk of pushing my luck, maybe we could take this one by. I do guess have another meeting coming up. We're getting pretty close with the bankers. There's a couple more technical changes, and I don't want to spend the committee's time trying to workshop it right here. Could we take this one by for the day?
184 will go by for the day.
Thank you, Mr. Chairman.
Okay. The next bill on the list is Delegate Hope, and you've got several bills. Is he here?
Thank you, Mr. Chairman. I do have a bill that I think is centered.
Senate Bill, House Bill 73 is the first one on the list, which also has to go to finance if it's reported.
Which one?
House Bill 73.
73.
That's the first one on our list.
House Bill, we do have some amendments. I do want to.
Do we have the amendments, Taylor?
Yes, Mr. Chair, they've been distributed, and I'll just report them quickly. The amendments I'll just take them in chunks because it might be a little bit easier. Amendments number 1, 4, and 6, I'll strike the language "or judgment is entered in favor of the defendant," and then amendments 2, 5, and 7 strike the corresponding judgment language. I'm referencing that. And then amendment number 3 on line 23, we're going to insert, the court shall not automatically expunge such records in an unlawful detainer action where a judgment is entered in favor of the defendant. However, such defendant may file a petition and the court shall, without a hearing, expunge such records in accordance with the provisions of subsection B.
Okay, do you understand the amendments? Motion and a second to adopt the amendments. All in favor, say aye. Aye. Okay, the bill's been amended. Delegate Hope?
Yeah, Mr. Chairman, this bill just has to do with once you have an unlawful detainer that has either been dismissed after 30 days or has non-suit after 6 months, or a judgment, in this case, we've added the amendment for a petition to be filed to be expunged from your record. So if you've been found that you've been satisfied, all these, your payments, it could be expunged from your record. Some of these records can stay on your record for more than 10 years.
I think what we have to see if anybody wants to testify about this bill. Okay, there's been a motion to report. Is there a second? Okay, unless there are alternative motions, please open the roll. Okay, Delegate Hope, your next bill.
Ayes 12, noes 1.
86.
House Bill 86, this also has to do with unlawful detainers, but this is more of a notification bill than anything else. In unlawful detainer cases, the plaintiff shall notify the full amount that's owed at the date of the hearing. This is really just a notice so that the defendant either coming in or doesn't come in, make sure that they have full disclosure of what they owe. There might be more payments that have to be accrued, and so that you would be permitted under the statute to make amendments under certain scenarios, but this just really clarifies what that process might be. But this is more of a notification of what you owe than anything else.
Okay, are there questions to Delegate Hope? Does everybody understand the bill? Okay, are there people in the audience that want to be heard?
If there's anyone online that would like to speak, raise your hand.
Okay, motion to report that's been seconded. Are there other motions? If not, please open the roll. Doesn't have to go to finance.
It does not.
So,
it does not.
There's been a motion and a second. Unless there are alternative motions, please open the roll.
Ayes 13, no zero.
You have another one, Delegate Hope.
Yeah, is House Bill 264?
House Bill 264.
And this,
We've already done that.
okay. And then the expungement, the 838
Yeah.
was already done.
838.
I'm out of here, Mr. Chairman.
You're out of here?
Thank you.
Okay. Delegate Watts, I think you're next. Yeah. Delegate Watts, in the first bill you've got is 76.
Yes. 76 comes to you by request of the Judicial Council of Virginia. The circuit court judges have reported that the current statutory oath language is not easily understood by grand jurors. The bill before you makes just editing change. There's no substantive change in the oath, but it does make it something that a grand juror can better relate to.
Just changes the language of the oath. Okay, does everybody understand the bill? Are there people here that would like to speak to this bill? House Bill 76.
If there's anyone online that would like to speak, raise your hand.
Motion to report in a second. Unless there are alternative motions, please open the roll.
Ayes 14, no zero.
Okay, your next bill is 77.
House Bill 77, as I approached the committee this morning, I had conversations with council. I would welcome some of their work on this bill, and I would ask that it be carried by for the day.
For the day, okay. That bill will pass by for the day without objection. Okay, do you have another bill?
I have another bill. It's House Bill 125.
125, House Bill 125. This has to go to Finance if it's reported.
House Bill 125 follows up on a bill that I carried last year on behalf of the fees paid for attorneys who are representing individuals who are in civil commitment proceedings. The fees had not been changed since 1998. Almost immediately, I heard from special justices as well as evaluators. The bill before you raises those fees as well. The amount that is raised is comparable to standard of living as of last year since 1998.
Okay, these are fees for like the special justices that handle
The
commitment hearings.
And the evaluators who can spend many hours.
And these fees aren't adequate as even as proposed, but there's something.
Mr. Chairman.
Senator Perry.
I just want to say a special thank you to Delegate Watts. I was a special justice for some period of time, and you're right, they're woefully underpaid. The independent evaluators are woefully underpaid. And it's the same thing as we see with court-appointed counsel, where it's difficult to get people sometimes to be willing to fulfill those jobs because you can spend a whole entire day trying to work through those cases that are incredibly important. So appreciate it very much.
Revert. Okay, we've got a motion to report and re-refer. Is there a second? Okay, are there people in the audience that need to speak to this bill?
Mr. Chair, we have one person online that would like to speak.
Okay, please, keep it brief.
David, you may unmute and please make sure your camera's on.
Unmuted. Is my camera on?
Your camera's not on. Just say whether you're for or against the bill, please.
I'm for the increase in pay. I think that's appropriate.
Okay.
There is another modification that needs to be made to the bill. The bill provides for the necessary expenses of the attorney and the examiner, but it does not provide for the necessary expenses of the special justice. The special justice has the higher necessary expenses because the hearing materials are provided to the special justice by email. The special justice prints those documents and provides a wet ink copy to the General District Court, The special justice records these hearings and provides the recording media to the court.
Okay, what's your name and where are you from, sir?
My name is David McCaskey.
Okay.
I'm a special justice in the 25th Judicial District. I serve Stanton and Augusta County.
Okay, thank you, sir. I haven't seen him in years. I haven't seen him in years.
I believe that.
Thank you, sir. Isn't it, they get mileage, parking, tolls, and postage, isn't that doesn't that always also apply to special justices?
Mr. Chair, that's correct. So the necessary mileage, parking and tolls and postage applies to the special justices. For the interpreter and the attorney, it says necessary expenses.
Mr. Chairman.
Senator Perry.
I will say the gentleman is accurate. The special justice is required to record the proceeding, and then we take a copy of that recording and make sure it's submitted to the court before the end of the day. The forms bother me less because you can get those from the court, but that is accurate that you do have to record it.
Would it help to have necessary expenses in here added?
I think it would be helpful if the patron is okay with it.
I'm fine with that.
You're okay with that? Taylor, where would that go?
Mr. Chair, it would go on line 16. We would strike mileage, parking, tolls, and postage and insert expenses.
Okay.
And then again on line 18, we would strike mileage, parking, tolls, and postage and add expenses.
So moved.
Okay. Does everybody understand that amendment? Okay. All in favor, say aye. Okay, what's your pleasure on the bill?
Move to report and refer.
Okay, motion to report and re-refer to finance. Unless there are alternative motions, please open the roll. Okay, thank you, and I turn
Ayes
it back
14,
over.
no zero.
I turn it back over to the real chair.
The coup is over. All right.
Thank you, Mr. Chairman.
Is House Bill 184 Simon, was that already by for the day?
Yeah.
Okay. So,
Simon's Martinez.
okay, we got Martinez up next, which I guess is 1470. 470, sorry. Oh, and this bill, I think, is very close to my bill, which was Senate Bill 502, but doesn't have the protective order piece, and it's a little different because it involves GALs. So, Doug Martinez, why don't you explain what your bill does?
Thank you, Mr. Chairman, for the opportunity to present my bill.
What's the next name?
The law currently states a petition for a child in need and services or supervision can only be filed by an intake officer. House Bill 470 increases the number of individuals who can file a petition for a child in need of services and supervision, a task primarily reserved for the intake officer. The new, I do have a substitute for that bill.
Okay, Senator Boysko moves, Senator Bagby seconds. The substitute, all those in favor say aye. Aye. Anybody opposed? No. Substitute's before us. What? Yeah, I don't have a substitute either, delegate, so I guess we moved a non-existent substitute. I think that was already adopted in the House, maybe? You have a substitute?
Well, what the substitute did was allow, if a parent was denied a petition, then the intake officer must.
Hold on a second, Delegate. Sabrina, what's going on with the sub?
I was just going to say, Mr. Chair, this is the bill that we have before us. This was the substitute that passed out of, or that reported out of House courts and reported out of the House.
Right.
So this is the bill before
Delegate,
us.
I got it. So, Delegate, your bill got a substitute on it over in the House. You don't need to redo the substitute again over here. So we're going to pretend like that motion didn't happen.
I remove my motion.
Because we didn't even have anything to move. So, okay? All right, Delegate.
Well, as a
So,
freshman,
Delegate, basically, your bill basically says that a JL can file a chins petition, which right now they can't. And then it also says that if an intake officer refuses a chins petition, they have to state their reasons in writing, provide a written explanation, which was the policy this committee already adopted in my bill. So basically, the new policy before us is whether JL ought to be able to file a chins petition or not. That's basically what you're asking us to decide today.
yes.
Okay. Does anybody have any questions for Delegate Martinez? Okay. Is there anybody opposed to the bill?
Is there anyone online that would like to speak in opposition?
Doesn't look like it. Huh? Mine had the protective order piece in it also. That was the controversial part.
Yeah.
Right. That's right. That's right. Yeah. So Doug, you've taken the part of my bill that was non-controversial and then added another non-controversial thing to it and didn't do the controversial part of mine.
Mr.
Okay.
Chair.
Yeah. Senator Jordan.
Thank you, Mr. Chair. Question for the patron. So it sounds like a great bill. Do you just have any specific examples of how the bill came about?
Yes, one of my stakeholders from Virginia now brought it forward, and essentially, when we were talking about it, we needed, we didn't want a parent who was wanting to file a petition or work with the intake officer just walk away with a no.
Okay. Doesn't look like there's any opposition to the bill. Senator Perry, you got a question? All right. All right. It's been moved. Senator Obenchain moves, and I think Peak or Stanley seconds. Stanley seconds. Stanley's getting anxious over there. Awesome. Okay. Clerk will open the roll.
Ayes 14 and no zero.
All right, Doug Martinez, I think you're out of here, right?
Thank you.
That's your only bill, right? That's your only bill, right? That's the only bill you have left, right?
Oh, yes.
Yeah, okay.
Thank you.
All right. Next on my sign-up list, wow. Jones, who's already had 3 bills out of here, and he wants another one. What do you got, Jones? Is it 246?
Yes, sir, Mr. Chair. Simply asking for.
You want to itemize fines and costs, I think, right?
Yes, sir.
Okay. Is there any opposition to asking the clerk of court to itemize costs on traffic infractions or violations of criminal law? Is there anybody opposed to that?
Is there anyone that would oppose online?
All right. Delegate Jones, you had opposition on the other side?
It was bipartisan.
Okay.
Bipartisan opposition.
Partisan. It was 65 to, let me find the.
All right. But I basically summarized the bill, right?
Yeah, exactly. Yes, sir.
Okay.
Second.
Okay, Perry moves, Deed seconds. The bill be reported and Finance has not requested it. Clerk will open the roll.
Ayes 14, no zero.
Bill reports.
Thank you, Mr. Chair.
Next on my sign-up list, I have Delegate Kent. Delegate Kent, welcome to the Senate Courts of Justice Committee.
Thank you, Mr. Chairman. Glad to be here.
And what, you got an easement conveyance?
Yes, sir. HB 879 is a technical bill that grants a right-of-way to the Lands and Wildlife Management Area. It's administrative. It's currently in practice. The Department of Wildlife Resources is currently doing this and allowing it and agrees with the bill.
Okay, and there's no opposition to the bill?
No, sir. None that I'm aware of.
Anybody online? Anybody in the public? It sounds like a pretty undefensive bill. Senator Obenchain moves. Stanley seconds to report the bill. Clerk will open the roll.
Ayes 14, no zero.
Thank
All
you,
right.
Mr. Chair, committee.
Won't be that easy next time. Next, I've got Delegate Coiner. Delegate Coiner, 648 contracts with inheritance funds. I think this one has a little bit of discussion with it, right?
Yes, thank you, Mr.
All
Chair.
right.
I do have something to be passed out to folks.
Okay, no subs or amendments though, right, Delegate? Okay. So Delegate, why don't you explain to us why we need to care about people getting advances on their inheritance?
Thank you, Mr. Chair. So the bill before you, you do have coming around what I'm talking about, so you can see an example. The letter that's coming around before you arrives in the mail in an envelope that on the outside looks like it's coming from the probate office. It says important probate documents do not bend. It looks very official. When you open it up and you're someone who has lost a loved one, there is a check at the top how easily you can get $20,000, no questions asked. So these probate lenders are checking local court records and contacting relatives of the deceased and offering them loans to, quote, unlock your inheritance and empower your future. This is a very profitable business. In fact, Consumer Reports said it is an obscure industry making money off of the dead. These companies, Mr. Chair, earn millions of dollars offering cash advances to heirs with effective interest rates as high as 490%. These companies claim that they are making advances and they are not loans, but Mr. Chair, I would assert that they are very similar to the same issue we saw in 2018 where the Attorney General obtained an injunction and multi-million-dollar judgment against future income payments on these pension advances. It's very similar fashion to those. So these companies are soliciting loved ones. They are giving them money that they may or may not ever see as part of an inheritance at very high interest rates. My bill is asking to bring them under our Fair Lending Act to put a cap on the interest rates and to require them to meet the same regulations that all other loans in Virginia are required to be under so that consumers are treated fairly in Virginia. Mr. Chair, you will hear from opposition that the reason to keep these as inheritance shark lending is because they are non-recourse. I will tell you 97% of these loans are paid, and therefore it doesn't matter if they're recourse or not. I'm simply asking that consumers are protected and at the most vulnerable moments in your life, that we're not allowing these folks to take advantage of individuals who may need immediate funds when there are other ways to do it. And that's what the bill does, Mr. Chair.
Doesn't look like a shark loan. It has this pretty little puppy dog on it. I don't know.
It looks nice, doesn't it?
Okay. Is that a beagle? Yeah, I don't think so.
That's not a beagle. Stanley, what are you talking about, man?
No,
it's not a beagle.
Yeah. All right. So, Doug, do you have anybody in favor, or is it just you?
There are folks here in support of the bill.
Okay, so why don't we set it to 5 and 5, MJ?
If there's anyone online that would like to speak in favor, raise your hand.
All right. Poverty Law Center.
Jay Spear with the Virginia Poverty Law Center, and we do support the bill. 4 years ago, this body passed the Fairness in Lending Act. Senator Bagby and Senator Locke did a great job of getting that legislation passed, and we totally redid our usury laws to include fairness to lenders and borrowers. And then we have groups like this that come in and make loans and say that they're not making loans just so they don't have to comply with that legislation. So what all that Delegate Coyner's bill does is say, yes, this is a loan. It comes under our usury laws. Just comply. If you want to make these loans, comply with our existing law. Thank you.
Okay, next.
Talia Mallory, Virginia NAACP. We support for the reasons stated by the Poverty Law Center. Thank you, Delegate, for the bill.
Mr. Chair, we have one person online that would like to speak.
Okay.
Matt, you can unmute and please make sure your camera's on.
Thank you. Good morning. My name is Matt Noam. I founded a company called Probate Advance, and I'm here today representing the Coalition for Responsible Beneficiary Funding, which is comprised of a number of the largest companies.
All right, Mr. Milam, are you testifying in opposition?
Yes, I am.
Okay, hold on. We're going to finish the supporters first, then we'll go to you.
Thank you.
Okay. Is there anybody else in support? No? Okay. So let's reset the clock. Is there anybody present who's opposed? One.
Julia Hammond with Cozen O'Connor on behalf of the Coalition for Responsible Beneficiary Funding. And we find what was delivered to Senator Coiner's house absolutely offensive. Members of the coalition do not in any way market in this manner. This is a company that is not part of our group, and in response to it, we had offered to the delegate amendment that would make this a penalty, that it would ban it, and if anybody chose to do it, there would be a fine or a penalty associated with it. That's how abhorrent we find the activity. Additionally, we do not see ourselves as loans, and we have two experts who are online who can go into greater detail. If they are recourse, you are now granting these companies the ability to collect, even if the individual did not receive money from the estate. If they are non-recourse, we are still required under IRS rules to issue a 1099 to the borrower. We think we are far more similar to a, what is the term? I'm staring at Stanley because I know he practices in this area. Please allow the two individuals to speak. Annuity purchase or structured settlement. That's the term I was looking for. I apologize. We have two individuals who are online who can speak to their practices and also answer any questions you have as to how they behave. We are regulated very heavily in California for the past 20 years. That's how we operate here in the Commonwealth of Virginia, and we'd be perfectly comfortable with something like that being adopted here in the Commonwealth.
Ms. Hammond, Senator Aird.
Mr. Chair, just a quick question for you. So in addition to the penalties that you're referencing, and I gather from what you're saying about not being a bad actor, is it fair to say that there may be bad actors in this space, though, that this legislation could help rein them in as well?
I don't think this legislation helps rein them in that you are now calling a business that is not a loan, a loan. I do think that there is means to rein them in, either under the California regulations or their code, which we would fully support coming here. And I can't imagine that there's another state that regulates this any stronger than what California does. But additionally, we also said that for the act that occurred, the mailing that you have, that should be banned. And we would also support a fine on top of that if somebody were to violate that.
Thank you, Mr. Chair.
Oh, yeah, his name was, yeah.
And the second one?
Is the online guy still there?
Are you looking for me?
Yeah, there he is. All right, go ahead. You got 3 minutes.
Good morning. Thank you for letting me speak. My name is Matt Millum. I founded a company called Probate Advance, and I'm here today representing the Coalition for Responsible Beneficiary Funding, which is comprised of a number of the largest companies nationwide that can contract with estate beneficiaries to purchase a portion of their future inheritance in unsettled probates. I'm also a locally elected official, so it's interesting to be on the other side of the dais. While we support regulation, our coalition is against this bill as it's currently written, and we appreciate the opportunity to testify and provide the industry's perspective. To begin with, I want to be clear that our members share Delegate Coiner's outrage that her children were sent a direct mail by a small firm in our industry who is not a member of our coalition. This should never have happened. All of our coalition members follow best practices that include screening out minors from any advertisement, and there's no excuse for this smaller company failing to do that. Incidents like this are exactly why our coalition supports regulation of the industry. We want to see all companies abide by a common set of rules to ensure that consumers are treated fairly. In fact, we propose that Virginia enact a law similar to that which has been on the books in California for almost 20 years. The California law formed the basis for industry best practices to which all of our coalition members abide. While I know that Delegate Coiner's heart is in the right place, there are significant unintended consequences of the House bill. First, mischaracterizing these contracts as loans creates a number of problems for beneficiaries. Our contracts are non-recourse, meaning that once the beneficiary receives payment, they can never be responsible for paying back that payment themselves, even if the estate takes years to settle or settles for far less than the amount of the advance. Under HB 648, these contracts would now be loans and would be recourse to the consumer. So, for example, in a case where an estate did not pay out or paid out less than the advance amount, the beneficiary would have to pay back the difference plus interest. To be clear, under the current contract, our members absorb those losses. Second, under IRS rules, if this becomes a loan, any amount that is not paid back becomes taxable to the recipient. Under HB 648, anytime one beneficiary in a probate of an estate decides
Hey, sir,
to
so
buy
make sure you
back-
know we got 30 seconds left unless you get a question.
Okay. So this bill was developed without any industry interaction and with a lot of incorrect information. Inheritance assignments are not done in the shadows. Every single transaction is filed with the probate court, served by mail to the Commissioner of Accounts, and subject to review by a judge. Our recommendation of a way to achieve Delegate Coiner's objectives without the unintended consequences are A, do not characterize this product incorrectly as a loan, B, explicitly state that judges can adjust the terms on a case-by-case basis if they find an agreement grossly unreasonable, and C, create a penalty for any company that sends direct mail solicitations to minors. Thank you for letting me speak.
Mr. Chair, for the witness, when you're...
Sir, what was your name again?
Matt Millam, M-I-L-I-M.
Thank you, Mr. Millam. Senator Aird has a question for you, and I got some questions too.
Thank you, Mr. Chair. I'm just really curious. The witness made several references to these unintended consequences, which I'm having a hard time wrapping my head around by the way this is structured. And so if you could give me an example of this fear of unintended consequences, I'd be really fascinated to know what that could be.
Sure. So if a consumer enters into an assignment agreement with us and they wind up not inheriting because there is a large creditor in the estate or because the executor found a will that was more recent that wrote out the beneficiary or any number of reasons that happen in the course of a probate case, if it's a loan, the counterparty on our agreement would be obligated to repay it personally. We never have that in our current construct, and we've never gone after a consumer for repayment. We get repaid by the estate only if and when the estate distributes out of our beneficiary share. So the consumer could be on the hook, and if it's non-recourse, the consumer would have an IRS bill.
Yeah. Senator Aird, you got another question? Hey, Mr. Millam, my question is this. When you say there's court approval, or court oversight, basically all you're referring to is that once you've signed an advance of your inheritance, the ultimate distribution of the estate is overseen by like a commissioner of account or a court approval or whatever. The actual terms and conditions of the actual advance itself is not something the court actually looks at and approves like it would with a structured settlement advance. Is that accurate?
No, sir, that's not accurate. Every single contract that we enter into is filed with the court and is fully visible and is a public document and it has the ability to have judicial review, every term and condition. The purchase price...
Right, sir, I understand that it's filed with the court, but that doesn't mean the court has to actually approve it in order for it to become valid like you do with an advance of a structured settlement. Is that right?
Well, they have to approve, the court has to approve the condition for distribution.
Right. Sir, can you tell me is there some kind of an interest, what you'd say is sort of an industry average interest rate on something like this?
We don't consider it a loan, so there isn't an interest rate, but in terms of a rate of return, it's difficult to say an average. Some cases take 5 to 10 years, some cases take a year, and since it's a purchase, there's a purchase price and an amount that we're buying. So, we don't know what that's going to be going in, but I could tell you factually, it is a tiny, tiny fraction of the number that Delegate Coiner mentioned. A tiny fraction.
Okay, sir, so you can't tell me what sort of an industry average is?
I don't know. I don't see enough information across the whole industry to actually tell you an industry average, but I can tell you it is a small fraction, a tiny fraction.
Got it. And sir, and also because you guys contend it's not a loan, that means that like a truth in lending disclosure is not accompanying the thing, so you can't get it converted into an APR, which a consumer could sort of easily understand. Is that right?
Truth in Lending Act does not apply. That is correct. Except even if we wanted to show an APR, we can't because we don't have a maturity date. We don't know when it's going to be repaid. So instead, what we show is very clearly on a cover page, and every company in our coalition does this. Here is what we are paying, and here's what we are buying in very plain language.
Okay, thank you. I think Senator Obenshain might have a question for you.
I do.
Sure.
If you can't give us a percentage or an annual percentage rate, I mean, are you telling us that it's a percentage of the amount loaned that is how you make money? Like half or a third of, say, the $20,000 advance that is given? Is that how it works?
It's a purchase, so it would look something like this. We are purchasing $15,000 of a person's beneficial interest in exchange, for example, for a $10,000 payment today, and then we wait. And if it takes 1 year, 5 years, 10 years, it's capped at the amount we purchased.
Okay, I think Senator Peake has a question if Senator Obenshain's done.
So, yep, Senator Overchain, were you done? All right. Mr. Chair, then to the witness. So based on what you've just told us, if someone was expecting a $50,000 inheritance, was hoping for a $50,000 inheritance, you would give them a $10,000 loan, and then if that inheritance came through in the next 6 months, you would get $50,000 and they would get 10. Is that correct?
No, sir. The number I gave was 15.
Oh, 15. 50. Okay.
Yes, and many of our agreements typically will have a provision to offer a rebate if a contract is repaid.
Well, Mr. Chairman,
okay, Senator Peake.
Question to the witness again. Then based, is there any guideline, any standard, any requirement, any limit under any code in Virginia that sets how you determine what you were going to pay for the expected return?
No, sir, there isn't, except when they're unreasonable, a judge can rule against them and say that this is unreasonable and they want to alter the terms.
Right. I think, Senator, it seems to me maybe if it's void against public policy or something like that for some reason, I guess, maybe. Okay. Any other questions? Yeah, go ahead, sir, Mr. Milne. Go ahead. We've asked you a lot of questions. You had something else you want to say?
Yeah, all the companies in our coalition offer a grace period of 5 business days. If somebody enters into an agreement and decides that they made a mistake, we allow them a way out.
Okay, thank you. It's an interesting product. I was totally unaware of this. So I think we're out of time on the opposition. Delegate Coiner, you want to have the last word, and then
Yes,
we'll
thank
debate
you,
it,
Mr.
bring it back to
Chairman.
committee level.
I think about the only thing he got correct and clear was that my heart is in the right place. When you can't answer questions clearly about what you're doing and there isn't a clear place for you in the code, I think it is very clear. We worked very hard in 2020 to ensure that consumers in Virginia knew they were being protected, knew that lenders were being protected, but that they do deserve to have a fair capped interest rate, and that is not happening in this space. These letters are not just going out to folks at their home. We had one person whose mother died, and he was incarcerated. They even mailed him one of these while he was incarcerated. We do have a place to bring these folks in under our current laws. And I'm asking, Mr. Chairman, that you would support the move to place these under our Fair Lending Act and ensure that consumers are protected in Virginia.
Thanks, Senator. So, and I would just note, I've been playing around. I clicked on the little QR code on your mailer thing here, and I've been Googling and stuff. There's a whole bunch of these online. myinheritancecash.com. There's all these videos and stuff. This one says, no interest, no stress.
Sounds great. My mother taught me if it sounds too good to be true,
Yeah.
it probably is.
Okay, so it strikes me that maybe perhaps, we can do this now, and if it's a real problem, we can come back and have a real regulatory structure next year if this is really problematic. But it seems to make sense to me. It's been moved and seconded by somebody down there who was Aird and Boysko that the bill be reported. Any further discussion? Clerk will open the roll.
Ayes 12, no 0, abstentions 2.
Thank you, Mr. Chair.
Thank you, Delegate Coiner. Next on our sign-up list, I have Lawfer, but I think we already did all of her bills, didn't we? She's not even here anyway, right? So then I got Delegate Green. And we've already done Greensville too, I think, right? Then I got Wilt next. Delegate Wilt, you want to give college students public defenders.
Mr. Chairman, if that's who needs it, then that's who we want to give it to.
All right.
Excuse me, Mr. Chairman and committee members. Yes, before you is House Bill 1014. It establishes a public defender office in Harrisonburg and Rockingham County. So the idea was brought to me recently by several interests back in the district. And, hey, there was this need. And I said, well, okay, forgive me, but I'm just not going to take your word for it. Show me the data, show me the figures. And so the Indigent Defense Commission went to work, and they did exactly that. And the bottom line on the data, Mr. Chairman, shows that short of Henrico, Harrisonburg, Rockingham County is the most needy for public defense. Henrico that doesn't have a public defender's office. Henrico has 175 certified court-appointed attorneys. Harrisonburg, Rockingham has 38. I mean, that's a huge discrepancy. And so, Mr. Chairman, I'm not going to delay the committee's time. I mean, that's it. That's it.
And
Mr. Chair.
Yes, Senator Deeds.
Harrisonburg used to have a robust criminal defense bar that's been decimated by the low fees that we pay for court-appointed lawyers. This is a glaring example of the need for probably a statewide public defender program.
Yeah, and Delegate, I know when we went through this in Prince William County and a couple others a couple of years ago, we looked at the finances of it. It's almost usually cost break even, maybe cost a little bit of money on, but usually get better effective representation. Is that your assertion here?
Mr. Chairman, yes, I would say that's correct. And yeah, we've got two directions. In the court-appointed attorneys, I mean, that's not going to go away, but it's going to lessen. And actually, the fiscal impact showed, money going back into the defense fund to a tune of about half of what this is going to cost. And so it's. I know there is some measures looking at increasing those the pay for the public, the court-appointed counsel, but dollar for dollar, this is our best investment.
Okay, I think Senator McDougal has a question. You have a question?
Mr. Chairman, we've seen some of these offices that we've recently approved not work out so well, and I don't know that I agree with your assertion that it's better representation. I do think that the focus needs to be on court-appointed, and that is a better way to make sure that you have practicing attorneys that are high quality. So I agree with Senator Deeds that the reimbursement for court-appointed attorneys has limited the number of court-appointed, and we've added additional obligations. If you are court-appointed to a DUI, you're probably spending 5 hours just reviewing body camera and preparing for the case, which is very different than where it was a short period of time ago. I don't know that this is going to be the panacea solution. So just that it's more of an overarching statement. I vehemently disagree with the statewide court-appointed system.
So I guess we won't be getting one in Hanover soon. I can tell the senator, at least in Prince William County, where we did it a couple of years ago, it's been a really big improvement.
Mr. Chair.
Yeah, Senator Deeds.
And unlike a lot, this is one that's been sought by the lawyers from Harrisonburg. I move to report and refer to finance.
Just so we can check really quick, is there any opposition to the bill, either online or in public?
Is there anyone online that would like to oppose?
Nope.
Mr. Chairman, is there anyone in favor, if it matters to the chair?
I don't think it's going to matter, unless you want to snatch victory from the jaws of defeat. No.
Defeat from the jaws of victory.
Yeah, I'm sorry. Yeah, I got it. Sorry, my bad. All right. Okay, clerk will open the roll.
Ayes 13, noes 1.
Great. Off you go to finance. Do you have another one?
Thank you, Mr. Chairman, committee members.
That's your only one, right? Yep.
Yes, sir.
Man, we are cooking with gas today. So I got
We're going to outlaw that.
cooking with propane. Propane or fuel oil. We don't cook with that anymore.
In the rural areas, that's the same thing.
Okay. All right. Next on my list, I have Cherry. I think we already did him though, right? No. HB what? Oh yeah. Is he here? He was here. Well, we'll come back to him. And then we got Simon, who's by for the day on his only one, and then that brings
Simon's, we've already done that. Simon's.
not Simmons. So not Simon's. I was like Delegate Simon. Yeah, he's done. Okay. Okay, let's go. All right. Yeah, you go up.
Thank
Shelley
you.
Simons,
Sometimes the confusion is to my advantage.
315.
HB 203 requires an online...
203. I'm sorry.
Yeah. Mr. Chair, HB 203 requires an online human trafficking recognition training module for certification for those employed in private security services. It directs the Virginia Department of Criminal Justice Services to create an online human trafficking awareness training to help recognize and report instances of human trafficking. This training program has actually already been created at DCJASC for hotel employees, and it came into effect last year, so we're expanding that to private security service officers. And I've got more context if you'd like me to continue, Mr.
So this
Chair.
just means if you want to become a certified private security officer, you have to go through this additional training.
Yes, it's online. It's about a half an hour.
Okay, doesn't sound very complicated. Nobody opposed? Okay, it's been moved and seconded. We report the bill. Clerk will open the roll.
Ayes 14, no zero.
Thank you.
All right. That's it, right? Okay, next up I have Shin. Juvenile fines and fees, judicial discretion, 1264.
Good morning. Good morning, Mr. Chair and members of the committee. You have House Bill 1264 before you, which did not have a Senate companion, but aims to empower judges to...
So this is like a different take, I think, on Aird's bill, was it? Like Aird said we don't have any fines on juveniles, and yours basically says it's discretionary.
So 1263, which was the bill that we conformed to Senator Aird's bill and reported and re-referred to Finance earlier this morning, and 1264 is just a different take on it, where 1263 and Senator Aird's bill looked at criminal offenses. This really just looks at traffic fines.
Okay.
And I think hopefully quite simply it just tries to empower judges to be able to use their discretion as it relates to the assessment of fines and fees for juveniles when they're in traffic offenses.
So you want to trust the judges we elect?
I would like to say yes, since we vote on them. And
Okay. Is there anybody opposed to this bill? I'm sure the judges looked at it. They probably said they liked more discretion. Most judges I know like discretion.
Mr. Chair,
Yeah, okay. This is
we
good.
also have, I work with the UVA Law Clinic on public policy, and so there might be some students who are signed up online who might want to also.
Oh, if UVA Law help, we got to let them say something. Are they online? I see Professor Block out there.
Mr. Chair, we have two people that would like to speak online.
Okay, the bill's in pretty good shape, so
I know.
I don't know if you guys want to speak or not, but
Bridget, you may unmute and please make sure your camera's on.
Good afternoon, Mr. Chair and members of the committee. My name is Bridget Harrington. I'm a student in the State and Local Government Policy Clinic at UVA School of Law. The views I express today are my own. Those of the University of School. I'm working with Diane to develop this legislation, and I'm here today to ask that you vote in favor of HB 1264, which will make our juvenile justice system more fair and effective. HB 1264 will make our system of traffic fines and fees for youth more fair by giving judges the ability to individualize the fine or fee imposed on a child and their family and make it just and proportional based on their economic circumstance. As you may know, many fines or fees right now are mandatory and don't allow for individualized accountability, which can result in financial hard.
Okay, your internet's getting a little choppy there, but I think we
Justice perspective.
Okay, thanks. Who's next?
Christopher, you may unmute and please make sure your camera's on.
Thank you, Mr. Chairman. My name is Christopher Lin. I'm a staff attorney with Juvenile Law Center, and we urge the committee to support this common sense reform. Thank you.
Great, thank you. All right, it's been moved and seconded the bill be reported so we can get these UVA law students back out on the softball field where they belong. And it has to go to finance too, I think. So moved and seconded goes to finance. Clerk will open the roll.
Thank you, Mr. Chair and members.
Ayes 9, noes 5.
Okay, next up I have, I think Delegate. Who's next? Cherry Shin McClure. Is McClure back? There she is. And Carr, you're next. Sullivan's last.
Hello, Mr. Chairman,
McClure,
members of the committee.
What do you got?
HB 586 directs the Department of Criminal Justice Services to create a model policy and training standards for law enforcement officers when administering naloxone for opioid overdoses. Law enforcement officers are typically the first emergency personnel to arrive on the scene of an overdose, so it's critical that law enforcement officers are prepared to administer that naloxone because it takes longer to provide treatment, the more likely the person will suffer from permanent brain damage if they don't administer that second naloxone in some cases. HB 586 would ensure that law enforcement officers have the standardized comprehensive training to effectively respond to opioid overdose using naloxone. Mr. Chairman, members of the committee, it is my hope that you vote favorably in favor of HB 586.
So, Delegate, you're basically trying to put in place a consistent statewide training on the use of naloxone instead of leaving it up to each department to figure it out?
That is correct, Mr. Chair.
Okay. Yeah, Senator Boysko.
Thank you. Mr. Chair, Delegate McClure, are you telling me that there is not already a consistent protocol for administering naloxone?
Mr. Chair, Senator Boysko, that is correct. I currently serve on the Substance Use Disorder Committee on the last 10 years, and so I've seen it done in my particular locality, but there isn't statewide training standards currently. The last time those particular standards have been updated was the 90s, and we passed this particular bill to allow officers to carry naloxone in 2015. That was a bipartisan bill.
Okay, any other questions? Okay, Senator Perry moves, Boysko seconds. We report the bill. You have a person lurking around over there. It looks like he wants to say something. Are you opposed?
He's in support.
Okay, nobody opposed out there? No DCHS problems, no chiefs of police problems, no none of that? Okay, clerk will open the roll.
Ayes 14, no 0.
Thank you, Delegate.
Thank you, Mr. Chair, members of the committee.
All right, next up, Delegate Carr, who has been patiently waiting.
Thank you. Always learn a lot, Mr.
Go
Chairman.
class of 2009. Delegate Carr, you've got 1126.
Yes, sir. Mr. Chairman, members of the subcommittee, 1126 simply adds members of the U.S. Senate and House of Representatives to the list of persons other than ministers who may perform rites of marriage. This grants our colleagues representing Virginia at the federal level the same privilege offered to members of the General Assembly, the governor and lieutenant governor, as well as the Attorney General of Virginia. I hope it will be the subcommittee to consider reporting 1126. This passed the House 98-0.
Yeah, they could. Okay, looks. You got questions over here? Okay. So, and Doug, we had a similar bill on this before, which authorized former people on this list to do it. And you're just adding another person to the Christmas tree. Maybe next year we'll have supervisors and school board members and everybody else, soil and water board and everybody on down. Yeah. But I don't know. Congressmen and senators are pretty prominent people. So it's been moved and seconded that we report the bill. Any further discussion? Nobody opposed? Okay. Clerk,
She's putting it in at their request, probably.
clerk will open the roll.
I think Bob Good asked for it. So you can vote for it. You can
Yeah.
vote for it, Mark.
I don't think Mark Warner can afford the bond.
Senator Subramaniam for Senator Carol Foy. Ayes 14, no zero.
Thank you, Mr. Chairman.
I'm sorry you had to wait so long for that.
Always learn a lot sitting in your committee.
All right. Hey, staff, could we make sure Cherry knows he's close? And did Delegate Simons, did both his bills go by or just one?
I think they passed, both passed.
One went by for the day. 315 passed? Oh, okay. Oh, good. 315 is a good one. Okay. All right. Sullivan, you got 640.
Thank you, Mr. Chair. Mr. Chair, not often, but too often, the Commonwealth incarcerates someone who we subsequently find out was innocent of the crime with which they were charged. There's a section of code that's long been part of the code in Virginia that instructs the General Assembly how to compensate someone in that situation. This bill further amends that section of code. I've had several of these bills over the last several years where we've been compensating people. The stories are always heartbreaking. And we have tinkered with the code with a couple of bills that I and others have worked on over the last, call it 6-7 years. So HB 640 further improves, in my view, the existing statute for how we go about compensating wrongfully incarcerated people in Virginia. The highlights are it does away with what is, I say technically, a guilty plea bar in the statute. I say technically because we have ignored it many times in the past. It adds compensation, extra compensation for someone who's had to spend time on death row or someone who's had to spend time on the sexual offender registry. It replaces the way we pay these people. In the past, we've done it with an annuity, meaning a small down payment and then an annuity for the rest of their lives. We changed that annuity a few years ago. This would just simply make it a lump sum. This is a debt owed these people by the Commonwealth, and we ought to just pay it rather than drag it out. It also adds a provision to reimburse these people for unreimbursed fines they might have had to pay. It adds the provision that an estate of one of these people would have standing to bring the claim. And it does, most importantly, I suppose, retains the requirement that the recipient release the Commonwealth from any further liability. In other words, if you take this money, you can't turn around and sue the Commonwealth. There's another provision already in law that says if you have sued the Commonwealth and then seek this, the amount you might have received from a judgment will get deducted from what you're due under this. I would say this bill does not increase the amount of compensation. We did that a couple of years ago where we upped the base amount to $55,000 a year, and it is indexed to inflation. I should say $55,000 a year or fraction thereof for the amount of the incarceration. These are people, again, just for emphasis, who have been found, they have writs of actual innocence or been found to be actually innocent of the crime for which they were jailed. That's 640, Mr. Chair.
Great. And Delegate Sullivan, thanks for the explanation. So was all this sort of your idea based on your years of working on this, or was there a group you're working with? Or?
Mr. Chairman, the answer to that is yes. As I indicated, I've done a bunch of these, and as I've done them, I've seen what I believe to be the flaws in the system as it was a few years ago. I should say I've also been working very carefully and closely with the UVA Innocence Project, who deals with these issues all the time, and they've expressed their concerns many, many times to me about the need to improve this statute.
Right. And I'm acutely familiar with this process because I carried the bill for the Norfolk 4 a couple of years ago, and several of them pleaded guilty because they were threatened with the death penalty and ended up having to.
Just last year, we approved a compensation for a gentleman who had pled guilty. Everyone on this panel knows there are any number of reasons why someone might plead guilty when they're in fact innocent.
Right. Okay. Is there anybody here to speak in favor of the bill?
If there's anyone online that would like to speak in favor, raise your hand.
No?
I don't think so.
Okay. Is there anybody here in opposition to the bill?
If there's anyone online that would like to oppose, raise your hand.
If it matters to you, Mr. Chairman, members of the committee, there was plenty of support for it over on the House side. Particularly, UVA showed up, and Ms. Hatchett, who runs this program, very in favor of the bill.
Okay, I think Senator Boyce is itching to make a motion. Okay, it's been moved and seconded. We re-report the bill to Finance. Is there any further discussion? Clerk will open the roll.
Thank you, Mr. Chair.
All right, off to Finance.
Ayes 14, no zero.
Say hi to Senator Lucas. All right, Delegate Cherry.
Yes, Mr. Chairman. How are you, sir?
Great. You promised not to score too many points in basketball this year?
I'll do my best.
All right. Well, I don't know. Maybe to carry this by for a week and talk to the basketball game. All right. Delegate Cherry, why don't you explain 823 to us?
823 was a great bill. You've already heard it. It is a companion to Senator Carol Foy's bill. Simply gives a definition for what is readily available, and that would be a 6-hour time limit.
Went to a different committee? Oh, we haven't seen it here because it went to a different committee. So, okay. Is it identical?
Yes.
Oh, you should have been on the identical docket instead of waiting around all day.
Okay. I thought it was. I'd asked this morning, and they said it was sent through already, which is why I left.
Okay. All right. Somebody down there moved and seconded. We report the bill does not need to go
Great
to
job,
Finance.
Senator. It was a wonderful bill.
Okay.
Yes.
Clerk will open the roll.
Ayes 14, no zero.
Okay, staff, can you confirm, does that complete our docket for today?
Mr. Chair, that does complete our docket.
Okay, committee, we did some good work today. I just want to note, I think we have about 80 bills left. We had another 50 that got assigned on Thursday. So we, I think, out of 151 or so, so we're about halfway through. So good work today. The committee will rise.
The Senate of Virginia, Richmond, Virginia.